So thrilled to have Susanna Popovic-Montag here with Ian to lead the webinar on resulting trust and unjust enrichment. And I'm going to do what I normally do, which is follow whatever Ian and Susanna tell me to do as far as switching slides. I also learned, to my surprise, yesterday that Ian, started as a will drafter in his early years and then transitioned to being a state litigator. It's good to know. Good to know. So I'm going to turn it over to you guys.
Sure. Thanks, Jordy. Hi, Susanna.
Hi there, Ian, and hello, Jordan, and everyone else. It's nice to be here.
Well, it's a great privilege to have someone another voice on the screen today, and I think, Jordy, you never really ever get a day off, and so I will ask you, just if you wouldn't mind, if I could put this to you at the starting point, because I have my own thoughts, but what the concepts of resulting trust and unjust enrichment at the solicitor's stage of your practice, how important is it, A, to understand, and B, to be translating these concepts to the client in your view?
Well, as I always say to my clients, ownership is the key element in estates because your will is going to cover what you own. And when we talk about ownership, of course, we're talking about beneficial ownership, which clients don't really think about. But that's the key thing. And so the element of resulting trust and presumption of resulting trust, and even other constructive trust claims, that all means that the ownership relies in someone other than who we think it relies in. And so that's why digging down on those issues and who is the real owner of things matters, because it's the assets of the real owner that are going to be governed by that person's will. Right? So.
Absolutely. And, this is coming back to your approach to planning generally. And it's, you really only have two ways to give away something. You've got the absolute and you've got the but. And this is what I describe as the hidden but in some cases, because it's not always intuitively understood by a client that there is a but. Until you sort of walk through the concept. So let's go to first principles. And Susanna, maybe I could start with you, if you don't mind. Let's break down resulting trusts at the high level and the presumptions that sort of surround it, and how you would be sort of, I would say, if you're in the solicitor's chair, how would you be pitching this concept to the client? And obviously would come up in a joint account situation as an easy one to illustrate with. But why don't you start us with, just to sort of get our sea legs on the concept, and as I say, how we plain English the concept.
Sure, Ian. And I think it really is important when we're taking, some information from our clients in terms of the nature and the extent of their assets to drill down into these concepts, because it will affect ultimately the ownership, or could affect what someone actually owns as opposed to what they think they own. So when we're talking about resulting trust, we start with a presumption that there is a presumption of a resulting trust that applies to some assets. And for instance, if there is property that's held by a party that has not contributed any consideration for it, has not paid for it, then it may be that it's being held in trust for the original title owner. And in that case, the presumption is going to rise to the surface and have to be addressed. It can also apply to gratuitous transfers between a parent and a child. And the easiest illustration, as you alluded to, Ian, is jointly held property. So that even though property is held jointly between a father and a son, for instance, and on the death of the father, one might expect that it would pass by right of survivorship. It's not always the case. And in fact, there's a presumption that it's the opposite, that if it's an adult child and a parent, then it's held in trust for the parent's estate. And when you've got a presumption, it's the starting point, of course, but it can be rebutted. And that's what we do when we have to, in terms of the litigation side of these things.
Sure. So we'll come to the next step, but Jordy's point about ownership drives everything in estate planning. And the second point, as you've described it, is contribution is relevant. and it does also drive ownership in the right circumstances. So that's really helpful. Okay, so as good lawyers, of course, we can't have a simple answer, and we have to say that presumption, which is hard enough for our clients to get their head around the concept. Then we have to start to break down in plain English this idea of rebuttable presumptions, and maybe you could tell us a little bit about that, but also maybe illustrate to us how you would manage that issue with a client in front of you, which is not only for solicitors work. We have to walk this issue through our clients all the time on the litigation side. So how do you approach it, and what are your thoughts, Susanna? And then maybe I might actually wake Jordy back up and have him give some initial thoughts too.
For sure. When we're talking about these things, I guess the real key with our clients is figuring out what the intention is. What is the intention in terms of what's going to happen to that asset when someone is gone? And if it is that it was supposed to be a gift, that it was supposed to pass by right of survivorship, for instance, in a joint account situation, then we're going to want and possibly even need some evidence in support of that, so that that can be verified. And so, the core decision back in 2007, it's hard to believe it was that long ago, is the seminal decision that talks about and explains these presumptions, I think, very, very well, and is the case that everyone refers to when we're talking about joint accounts and assets being held with adult children. The key really is to figure out what it is that the intention is. Is it a gift, or is it really just being held so that on the death of the parent, it goes back into their estate, and then pursuant to their estate plan, their will, or some other arrangement? And that's the real key.
Jordy, like this is a concept that you're struggling with your clients all the time, and again, we want to be efficient with our intake step. What if anything else would you add to how you're going to get through this issue with the client and leave them understanding it? And that this may tie to your visualizations and some of the other tools you use.
Well, the way I explain this concept is this, that the law struggles with people acting generously. Okay, people paying for something that they're not keeping. And so this is the way the law deals with that. It says that if you're taking your own money and buying something that you're not going to own, we're suspect. The law is a suspect of that. And so we're going to make sure that you really mean this as a gift. That's really, at the end of the day, that's what this whole presumption of resulting trust and all of this stuff is about. It's about this idea that the law struggles with the fact that why would somebody pay their own money not to get something? And so that's why I would say that the law wants to know, when you give something to someone for free, did you really mean it? It's like you get another chance. Yeah, sure. Because the law doesn't make sense to the law. Why would you be doing that? The only time it makes sense to the law, in two cases. One, and Susanna has highlighted this here, it's when a parent spends money on a minor child. Then they're like, okay, yeah, that makes sense. The law says, yeah, that makes sense. And the other is between spouses. Sometimes there are those kinds of, although not always, those kinds of situations. So, and our law actually distinguishes between when it makes sense that there's a gift and when it doesn't. And so that's how I try to explain it to clients. If you're giving something to someone, or you spent your own money on someone else's asset, the law is going to be concerned about that.
That's a great way of putting it, and it's really I know you teach up at Osgood, and your courses in large part looks at sort of the broader principles behind the wills and estates law, and I think that's a really helpful way to sort of get clients focused on and understand better these issues by describing it. That was excellent. All right, so Susanna, just coming back to the litigation hat, because at the end of the day, we're going to need evidence. We're going to need proof of the rebutting, and maybe you could talk a little bit about what evidence has been seen as sufficient evidence to rebut the presumption, and where maybe some of the cases commented on that. And we'll go to the next slide if we could, Jordy.
So sorry about that. I was having some technical issues, so I didn't get to hear any of Jordan's comments. So if there is a bit of overlap, I apologize. But when we're looking for evidence that's going to overcome this presumption of resulting trust, the key evidence I mentioned earlier is that of intention at the time of the transfer. And that really is the key moment in time when the property is made joint, for instance, or it's being transferred in some way, shape, or form. What did the deceased intend at that time would happen to the property upon his or her death? And so where do we get that kind of evidence? We can look to, when we're dealing with bank accounts, with joint bank accounts, the bank documents, what the bank documents say. And for the most part, we know that they talk about most likely a right of survivorship, but that's just like one piece of evidence. If that's not in fact what was intended, then we're looking for other pieces of information. A good illustration of that, of course, is the control and the use of the funds in the account. So once they became joint, who continued to use those funds, who contributed to those funds? Was it only the parent, or was it the parent and the child, or was it only the child? And hand in hand with that comes the tax treatment of the joint accounts, which also helps a lot. It's one thing to say, oh, it should pass all by right of survivorship because it was intended to be a gift. But if the account, the tax that was generated by that and had to be paid was paid by the parent, then that speaks to a different intention and a different result ultimately. And when we do have lawyers and solicitors involved, their evidence may be quite important when it comes to actual time of transfer and their involvement in what discussions were had about what the real underlying intention was at the end of the day.
All right, so I want to, Suzanne, I'm going to come back to you in a moment. I just want to talk about the Komolsky case and the MAC decision in a moment, but because I think that those are really good illustrations of the beyond PCORI. But Jordy, can I just come back to you on one point? Was that, and we saw in the Globe and Mail this week that article that talked about the average parent is giving about $134,000 contribution towards child's purchase of their home now. And it was an interesting article just in terms of transfer of wealth. But that just makes me think that on the solicitor side, you must be seeing this issue more and more where the parents have given, and that comes to a whole new topic of hodgepodge. But just in terms of the resulting trust concepts and that idea that parents are dropping that kind of serious money towards their kids' housing purchases. Does that tie in at all in your practice when you're dealing with the resulting trust issue?
Yeah, it does. I mean, anytime money's advanced, I want to clarify, is it a gift or is this a loan in essence? I mean, that is what that's what a resulting trust is in essence. It's a loan. And it's a fancy way of saying that. It's saying, who does this money really belong to? And so, yeah, I want to clarify that. And the will, if you're drafting the will and you want to make that clear, that you might want to forgive, even if they are loans, you want to forgive them or advances. So, yeah, I think it's the best advice to people who are giving money to their kids is to document it. It's a gift or it's not a gift and it's a loan.
So, all right, the joy of being a litigator, Susanna, we see cases out there that some might say are a bit wonky and some might say got fixed or didn't get fixed. We went through that with the Milne decision, and we've gone through it a little bit with the Komolsky and the MAC going back and forth. Maybe, would you mind just speaking to that at a high level, what happened there and how the ship was righted, so to speak?
So in the Komolsky decision, we saw for the first time a very interesting application or extension of the PCORI principle. And what the court in Komolsky did back in 2020 was to consider the applicability of a presumption of resulting trust to a beneficiary designation. So we had always had the resulting trust presumption being applied to joint accounts or assets held jointly with an adult child. But in Komolsky, the court extended it and held that, in fact, there was a presumption when a beneficiary, an adult child, was designated as the beneficiary of an insurance fund. And so that really shook up our bar quite strongly, because no one had ever expected that to be the case. And many, many people commented on it. And there was a lot of criticism of that decision as well. And it wasn't until the next year in the Mac estate decision where the opposite result was ultimately reached. And the court said, no, we don't apply that presumption to beneficiary designations. And so the problem with Kalmusky is that it was never actually appealed. And so now we have two competing decisions of the Superior Court, one that says, yes, it does apply, and the other that says it doesn't. And I think until we get a higher court's ruling, people are just going to choose the one that they prefer for their purposes and make that pitch. But, it was good to see that Matt came around and certainly clarified things for many of us, or at least validated what many of us thought was the right result. But we're still going to have to wait to see how it ultimately plays out.
So Jordy, are you revising your thinking at all on the planning as a consequence of what litigators see as a bonanza of chaos?
One of the things that I include through eState is the option to confirm that joint assets, which had a presumption of resulting trust, and beneficiary designations are intended to pass to the designated beneficiary and the joint owner, both beneficially and legally. And so confirming that I really meant it as a gift and not as not to be held on a resulting trust. So that's actually something on each document that I have the option of including or not including, depending on the circumstances. You may not include it. If the residuary beneficiaries are the same as the designated beneficiaries, then there's nothing to worry about. But if you're, for whatever reason, designating one person as the beneficiary of an RSP and different residuary beneficiaries, then you'd be wise. I think I'd want to consider, is it a true gift or is it held on a resulting trust, and then include the relevant language in the will.
That's terrific. Good catch. And nice to be able to say I really mean it in a sort of a professional way. All right, well, let's go to the next slide if we could. This is, we're going to introduce this concept, and Susanna is going to introduce this concept in a moment, a concept that was near and dear to both Susanna and my hearts, as we both spent an inordinate amount of time preparing and attending the Supreme Court of Canada on this very issue of unjust enrichment. But before we sort of break it down, the concept, Jordy, can I just impose on you again, just to give us your professorial / plain English description that you provide your clients, in these when this issue has to be addressed with them?
Yeah, this is less common on the drafting side, obviously. This is much more common on your side. But this is one of those where the law steps in because something's not fair. So you got the benefit of something and you didn't have to pay for it. And that's this is kind of a mirror of the resulting trust argument. But basically, it's the person got a benefit. I suffered a loss, and there's no real good reason for it. And that's the essence of unjust enrichment. It, at least, unlike a resulting trust, which doesn't make sense to anybody, why it's called a resulting trust, at least unjust enrichment makes you can sort of figure out what they're talking about here.
Yeah, and I think as Susanna is going to break down the case in a moment with the courts have approached it, because it's good to have this basic understanding, but it's also fundamental. Unjust enrichment is fundamental to equitable principles. And so it's sort of, I've always kind of looked at it as the overlay in respect of many of these issues. And certainly the courts have approached it that way. But so Susanna, because we're not in kindergarten and we can't just turn to our friend and say that's not fair and win, what do the courts do to break down the concept of unjust enrichment in a way to determine whether or not a remedy is going to be available for that particular unfair or fair conduct on the part of an individual?
Well, I think as Jordy said, it's really a three-part test that the court's going to apply. It's going to definitely want to have someone demonstrate that there was someone who benefited at the expense of someone else and that there wasn't a good reason for it. So each of those components were, set out back in the 1980 decision of Becker and Petkis, and then reiterated in our decision of Moore and Sweet. But it really is just that, a three-part test. And for the most part, we find that the first two parts of the test are the easier ones to overcome. The last one, the absence of a juristic reason, is the tough one. And we've certainly took us a long time to really delve into what does a juristic reason really mean, because it's not as simple as it seems. And we want to keep in mind, though, that unjust enrichment really is a cause of action. So when someone wants to allege that something is just not fair, they do have a means by which to do it if they can establish the three parts of the test. And we know certainly that because it is an equitable remedy, there is a lot of flexibility there. It is a lot of subjectivity too to the judge who's ultimately dealing with the allegation of unjustness or unfairness. And so it's a difficult concept to explain. I mean, it's a simple in that sense, but it's difficult to actually prove in certain cases, depending on whether or not you can overcome that last part of the juristic reason part of the test.
And Jordy, again, I think your comment is dead on, that this isn't something that you're typically winding through with a client in an intake moment very often. But when this unfairness occurs, do you have anything else that you add in terms of the steps that the court might consider taking in the process of coming up with determination? Because of course, the unjust enrichment itself isn't the cause, is the cause of action. It's not the remedy itself. If we're coming at this on a solution based.
You like to ask questions, eh? Yeah, as a panelist. You take over.
You can ask the questions. You can.
No, I'm just kidding. I'm kidding.
I love it.
Ian,
yes.
I'll get you back for this. That's okay. Yeah, I mean, the juristic reason is the problem. What does that mean? And of course, that was the Moore and Sweet. That's what you guys struggled with and convinced the Supreme Court about. It's really that there's a reason why you got the money. Why did you get the benefit? And is there some legal reason why you got the benefit? For example, if you're in that case, it was a beneficiary designation. And the question was, why should you end up with the money versus this other person? But the fact of a beneficiary designation was in fact that the juristic reason for getting money. If I'm a beneficiary of a life insurance policy, I get the money. That's a benefit. Someone else is deprived of it. Well, that's okay. There's a reason for it. The reason is I was designated as the beneficiary. So that's the kind of thought process that the court is looking at. What's the legal reason for you getting this benefit while other people didn't get it? I don't know if that answers your question or not.
No, that totally does. And that's a great way of describing the juristic reason language. And look, academics, since it came out, the test came out from the Supreme Court of Canada, have toyed with the concept of juristic reason. Is why is that language itself isn't very plain English in its own way. So I like the way you've described it. All right, we've only got a few minutes left, so I want to just touch on the constructive trust, which is the final component of the sort of equitable remedies that are existing. And of course, constructive trust is part and parcel of the unjust enrichment sort of umbrella. But Susanna, would you mind just giving us sort of your overlay and observations on the concept, and then love to hear from Jordy in terms of how he manages his clients with this concept.
Sure. So the constructive trust is, again, a remedy, a little bit different from unjust enrichment, which is a cause of action. And what it is it comes into play when the court decides that something is just, it's against the court's good conscience, and it just screams out or requires the imposition of a constructive trust in order to remedy the situation. And the key with a constructive trust, though, is that there is no need for an intention to create a trust. And it's just the fact that it just doesn't sit right with the court, and that good conscience doesn't allow someone to benefit at the expense of someone else, and it has to be corrected. And in those cases, the court will impose a constructive trust to remedy what is an otherwise clearly unjust situation, but wouldn't necessarily fit into the unjust enrichment test, or wouldn't fit into a resulting trust situation. It's just one that it's a remedy that just fixes a situation that doesn't fall within the other categories.
Excellent. Jordy, again, when you've got a glassy-eyed client across the table, how are you, or on the Zoom call, how are you dealing with this issue?
So this sometimes comes up because you might be acting for one spouse, and they say, "Oh yeah, everything, everything's in her name, and it's as a result of my hard work in the law firm or in the business or whatever, that that it's increased in value. I built the home," or this sometimes happens with a kid who's contributed to the home and in renovating it, et cetera, but it's owned by the mom. And so we're planning for the mom's, she said, "Well, I want it to go to son X," but meanwhile daughter Y was the one who was doing all the renovations. And so I'd say, well, hold on, think about ownership here for a second. Maybe the law is not going to let you keep the benefit of your daughter's hard work. Yes, you didn't pay her, but that's not fair. And that's the classic constructive trust, where you've made a contribution to value, but you're not owning it. And so that's why you'd have to warn the client, either in a spousal situation or a child situation where somebody else has been contributing to the growth of their assets, that maybe ultimately a court might say you don't own all of it. You only own 70% of it, and 30% is owned by the person who contributed to improving it. That's a constructive trust. And of course, then the parent can only give away their 70%. They can't give away the 30% that doesn't belong to them. And they might not know that until after they die. They might never know that there was a constructive trust claim that was brought after death. Right? That's the tricky part, because you might not have given the same amount to that person if they were going to end up owning 30% of your property after you died. So it can get very tricky.
All right. Well, I really like that. And I think as we sort of rolling our time up to 2 minutes before 1, Jordy, we're exhausted. I don't know how you do this every week. We're going to pass this back to you, and we're going to take the next month off because this is just too much. We appreciate
Susanna,
you bringing us.
That's what I would say, Susanna. You were fantastic. Ian, that was not your greatest performance, and we're going to let you off the hook. Remember, Anyway, Susanna, thank you for your time. Thanks everybody else for your time, and glad Susanna was here to actually add some value. I don't know if anybody has. There's a couple of questions that we can answer if anybody has in the last couple of minutes, and about these constructive trusts. One of the tricky ones that I've come across with constructive trust is where you've got a separated spouse, or a spouse that they're not separated, but there's some issues there, and they're trying to provide for their spouse, but they want something. If they end up owning 100%, fine, they'll give their spouse something. But if their spouse makes a constructive trust claim after death and ends up owning 50%, well, then there would be a different disposition, and quite frankly, almost impossible to deal with. I mean, I guess you could say, well, if my spouse if I end up owning 100% of this property, then I want to do this. If someone else owns part of it, I want that to be done. That's literally what you'd have to think, because of course the constructive trust claim is not likely to be brought during lifetime. It's going to be brought after death. So it's a, you know, it's a difficult position, because unlike a family law act election where, you know, sure, we know how to remedy that, because automatically the spouse is disinherited out of the will if they elect under the family law act. There's no such provision for a constructive trust claim, so you might get both. So that's just something to keep on top of your head if you see the fact pattern there.
Excellent. Well, Jordy, it's always a pleasure.
Thank you,
Susanna,
Ian.
great to
you,
have you
Susanna.
on the channel, Susanna. We'll have to give you back more often. And everyone, back to you, Jordy, and have a nice weekend.
Thanks, everybody.
everybody.
Hope to,
Take care now.
thanks, Susanna. Thanks to everyone, and hope to see you guys again next week.